3, 2, 1.
Okay. Hello, everyone, and thank you for joining us for today's National Conference of State Legislatures webinar, Who Decides the State's Energy Mix? My name is Christy Hartman. I am the Director of NCSL's Energy Program, and I will be moderating the webinar today. This is the first webinar in NCSL's Natural Resources and Infrastructure Committee's 2020 Spring Webinar Series. We have a total of 5 webinars lined up between now and mid-June on a variety of topics, including a review of the new Waters of the United States rule and how states are responding to those jurisdictional changes, solar on agricultural land and the preservation of pollinator habitat and soil health, an overview of traffic safety and legislative trends across the states, and a look at how states are meeting clean air standards as they deal with an increase in emissions from exceptional events. But to start off the series, today's webinar will focus on the Federal Energy Regulatory Commission's minimum offer price rule. FERC's MOPR has garnered a lot of attention, especially over the last several months, due to its impact on the nation's largest electricity market, PJM. We've got a great panel today who are going to talk more specifically about the MOPR, how it affects regional power markets like PJM, what the impacts are on the energy resource mix, and how states are reacting to this order. Today's webinar is a platform for informational exchange and engagement. Over the next 60 minutes, we encourage participation through our chat box, so feel free to type your questions and answer any questions in the chat box, which is in the lower left-hand corner of your screen. Please feel free to ask a question at any time, or I invite you to type in the state from which you're calling from now if you'd like to test it out. We will hold some time for Q&A after our presenters are finished speaking. The webinar is being recorded and will be available along with the presentation slides on NCSL's website within about a week. Additionally, you can download the presentation slides being used today by clicking on the Resources tab or the Speaker tab for the speaker bios at any time during the presentation. Today we have 3 great presenters who will share their expertise on these issues. And remember to click on the Speaker tab to read their full bios. Our first speaker today is Romany Webb. Romany has been with the Sabin Center since 2016, and her research focuses on the intersection of climate and energy. Today, Romany will share some background on how wholesale energy markets operate and how FERC's order impacts energy resources and state policies. Romany, thank you for joining us today. The floor is yours.
Thank you, Christy, and thanks to you and the NCSL team for organizing today's webinar and inviting me to participate. It's really nice to have the opportunity to come together and talk energy, particularly in the current environment. The question that's been posed for discussion today, who decides the state's electricity mix, is actually quite complex because electricity is, of course, one of those areas where regulatory authority is divided between the federal government and the states. And whilst the division was once very clear, there was what the courts referred to as a bright line between federal and state authority. Over time, that line has become increasingly blurred, and that has created tension, which is to some degree heightened in the current political environment, where the federal government and the states have many states have conflicting energy policy goals. Most recently, as Christy alluded to, we've seen this play out in debates surrounding PJM's wholesale markets, in particular the wholesale capacity market, and in FERC's order regarding the minimum offer price rule, the MOPR. As Christy said, I was to sort of provide an introduction to the MOPR and FERC's ruling, but first I'm going to just provide a little bit of background on the broader framework in which FERC is operating. So the starting point, of course, is the Federal Power Act, which divides regulatory authority between the federal government and the states. Section 2 of the Federal Power Act gives FERC exclusive jurisdiction over the transmission and wholesale sale of electricity in interstate commerce. That is the limit of FERC's jurisdiction, and other matters are reserved to the state. So I'll talk a bit more about that in a minute. But for now, focusing on FERC's authority, as I said, it regulates wholesale sales in interstate commerce. The Federal Power Act defines wholesale sales as sales of electricity to any person for resale, and sales are considered to occur in interstate commerce when the electricity is transmitted from the seller to the buyer via an interstate grid, which is a requirement that's met in most cases. Interstate grids are used to transmit electricity throughout the contiguous United States, with the exception of Texas and parts of Maine. So except in those areas, all wholesale sales are regulated by FERC. FERC is charged under the Federal Power Act with ensuring that wholesale rates are just and reasonable and not unduly discriminatory or preferential. And in many areas, rates are set through wholesale markets. The wholesale markets are, as many of you will know, operated by entities called regional transmission organizations or independent system operators, which are responsible for managing the grid, the transmission grid within a particular area. There's currently 7 of them, 6 of which are regulated by FERC. The only one that's not is ERCOT, which manages much of the transmission grid in Texas. As Christy said, the largest RTO is PJM. It manages the transmission grid covering all or part of 13 states and DC. The area that the PJM region includes about just over 1,300 generators and about 84,000 miles of transmission. And within that area, there are about 65 million customers. The electricity that those customers receive is transacted through wholesale power markets. PJM operates 2 wholesale energy markets through which generators and other suppliers sell electricity for basically immediate use. PJM also operates a capacity market, which is designed to ensure that there is sufficient capacity to meet projected future demand, plus what's called the reserve margin. It's important to note that not all ISOs and RTOs have capacity markets, and not all capacity markets are the same. PJM capacity market is forward-looking. It operates 3 years out. So each year, PJM holds an auction through which it procures capacity for a 1-year period, 3 years in the future. I'm not going to spend a lot of time on how the auctions work, but very simply, it's a bid-based process. Suppliers submit bids indicating the price at which they're willing to supply capacity, or in the case of the energy markets, electricity. The ISO or RTO ranks the bids from lowest to highest, and then starting at the low end, it accepts bids until the amount of capacity or electricity that's needed is met. The last bid accepted sets the market clearing price, and anyone who bid in below that price is said to clear the market and receives the market clearing price regardless of the level at which they bid in. So this market or auction structure is intended to, and for the most part does, create an incentive for suppliers to bid into the market at the lowest possible price, because of course the lower a supplier bids in, the more likely it is to clear the market. But it's important to recognize that some ISOs and RTOs have adopted rules like a MOPR that constrain suppliers' bidding behavior. And so through those rules and through their control of the markets more generally, the ISOs and RTOs can indirectly influence the generation mix. But FERC certainly does not have authority to directly regulate generation. That is a matter that is reserved to the states under the Federal Power Act. So, for example, it is the states that are responsible for approving new generating facilities and regulating their construction and operation and retirement. The states can, and many have, adopted policies or taken other steps to support particular types of generations. So recently we've seen many states adopting policies aimed at supporting renewables or other forms of low carbon generation. This graphic, which hopefully is readable, shows some of the clean energy policies that have been adopted in PJM states. And in the lower left corner, you can see that 11 of the 13 states plus DC have some form of renewable portfolio standard or other renewable energy goal. Some of the states have also adopted policies aimed at supporting nuclear generation, which is shown at the top in the orange. For many years, traditional generators, principally coal and gas generators in the PJM region, have complained that these state policies have a negative effect on the capacity market, and in particular suppress capacity market prices. And so the basic argument is that through those state policies, certain generators receive revenues outside the market. The fact that they receive those revenues allows them to bid into the market at a lower level, which suppresses overall capacity market prices. So that argument was made in a complaint filed with FERC by Calpine Corporation and some others back in 2016, and it is that complaint that led to the FERC orders that we're talking about today. There were sort of two key orders, and this graphic should actually have an additional data point on the end, but the two main orders which are most important for our purposes are the June 2018 order and the December 2019 order. In the June 2018 order, FERC responded to Calpine's complaint and basically accepted its argument. FERC said that state support for particular generation resources threatens the integrity of PJM's capacity market. Specifically, it said, and I quote, "Over the last few years, the PJM region has experienced a significant increase in out-of-market payments provided by states for the purpose of supporting the entry or continued operation of preferred resources that may not otherwise be able to clear in the competitive wholesale capacity market. Such uneconomic entry and retention allows for the distortion of capacity market prices and compromises the ability of those prices to serve as signals for the efficient entry and exit of resources." In this June 2018 order, FERC declared that PJM's existing tariff, which sets out the market rules, failed to adequately address that impact and so was unjust and unreasonable. At that time, FERC rejected two market reforms that had been proposed by PJM to address the impact of the state programs, and it did not reach a conclusion on what the replacement rule should be. It did that in the December 2019 order, in which it directed PJM to expand the minimum offer price rule, the MOPR, that applies in its capacity market. So what is the MOPR? In very simple terms, the MOPR sets an offer price floor or minimum at or above which certain resources must bid into PJM's capacity market. This offer floor concept has been part of the capacity market construct since it was established by PJM in 2006. At that time, the MOPR only applied to so-called net buyers of capacity, entities that bought more capacity through the market than they sold, and the MOPR was used to prevent those entities submitting artificially low bids so as to reduce the market clearing price and thereby lower their overall capacity costs. In 2013, the MOPR was expanded to apply to certain new gas-fired generators, and in the December order that FERC issued last year, it directed PJM to further expand the MOPR to apply to all new and existing capacity resources that receive or are eligible to receive state subsidies, subject to limited exceptions that we'll talk about in a moment. This graphic shows the effect of expanding the MOPR. Basically, what it means is that state subsidized resources, which are, for the most part, but not only, renewable resources, have to bid into the market at or above a specified price floor, which is by design higher than the amount they would otherwise bid. And that makes state-supported resources less competitive in the market, and so means they are less likely to clear. So, who does this new expanded MOPR apply to? As I said, in the December 2019 order, FERC directed PJM to expand the MOPR to apply to all state-subsidized resources, both new and existing, regardless of size or type. So the order covers generation, storage, demand response, energy efficiency resources that participate in the capacity market, that receive or are eligible to receive state subsidies. And the order includes a very broad definition of state subsidies. The definition captures any out-of-market payment provided or required by a state that could have the effect of allowing a resource to clear the capacity market. FERC has clarified that it includes RPS programs that lead to the sale of RECs. It also includes ZEC or zero emission credit programs that are aimed at supporting nuclear generators. In an order issued last week, FERC did clarify, though, that it does not extend to carbon pricing schemes like RGGI, because those schemes don't involve a payment to generators. A couple of things to note about the definition. FERC has said that it is aiming to capture out-of-market payments that support the entry or continued operation and participation of generating resources that might not otherwise succeed in the capacity market, but it's not requiring any showing that the state support actually allows that or results in that effect. The other thing that's interesting is that FERC has explicitly excluded from the MOPR resources that receive subsidies under federal law, despite recognizing that those resources have the same ability to, in theory, suppress capacity market prices. Along with federally subsidized resources, there are some exemptions for state subsidized resources. The exemptions are fairly narrow and mostly benefit existing resources. So there are 3 existing resource exemptions for renewable resources that are covered by RPS programs, demand response, energy efficiency and capacity, storage resources, and self-supply resources owned by vertically integrated utilities. There's also a competitive exemption under which resources can pledge to PJM that they will forego any state subsidies for which they might be eligible. And if a resource makes such a pledge and then later accepts a state subsidy, it would lose its capacity market revenue and be prevented from participating in the market. And then finally, there's a unit-specific exemption through which resources can justify offers or bids below the minimum set by the MOPR. So I think Jeff is going to talk a little bit more about some of those exemptions and how PJM is proposing to operationalize the order. So I will leave it there.
Great, thank you, Romany. I think that was a great presentation and a good overview, not only of wholesale power markets, but also FERC's MOPR. I do want to mention to the audience that we will have time for questions at the end. So if things come up in these presentations and you'd like a question addressed on this webinar, go ahead and type it into the audience chat box, and I'll collect the list and we'll ask them at the end. I'm now going to turn over to our next presenter today, who is Jeff Dennis, who is the Managing Director and General Counsel for Advanced Energy Economy. Jeff leads their work to increase wholesale electricity market access for advanced energy technologies and provides legal advice and counsel to all of the organization's programs. Before joining AEE, Jeff spent over a decade at FERC, and today he's going to talk more about the impact of the MOPR on advanced energy resources and the overall energy mix. So with that, Jeff, the floor is yours.
Well, thank you, Christine, and thank you to you and your colleagues at NCSL for inviting us. Really appreciate the opportunity to talk to you a little bit about these issues in wholesale markets. Let me start with just the brief obligatory commercial about who we are. Advanced Energy Economy is a broad tent trade group that represents more than 100 companies and organizations across what we call the advanced energy industry and its value chains. And so when I talk about advanced energy today, I'm going to be talking about a broad suite of technologies, including energy efficiency, demand response, solar, wind, storage, electric vehicles, lots of the enabling infrastructure like advanced metering, transmission and distribution technologies, fuel cells. Really, we run the gamut of these technologies. Our membership also includes a number of Fortune 500 companies with goals for procuring more of the energy they use in their operations from clean advanced energy resources. So there's kind of 3 objectives I wanted to cover today, 3 takeaways I wanted to leave you with. First, I wanted to talk about how FERC's Broad MOPR, as we call it, will impact advanced energy resources supported by state policies. And I'm going to be talking a lot about how PJM proposed to implement the order. Romany did a great job laying out what the order says and what the order required PJM to do. PJM was then obligated to turn those directives into specific tariff or market rule language that will be on file with FERC. And so I'm going to talk a little bit about that. That filing was made on March 18th of this year and reflected a lot of work that folks like me and many other folks in our industry did working directly with PJM to shape that filing. As Christy said, I'll talk a little bit about how MOPR impacts the energy mix, customers, and clean energy policies in the PJM region. And then I do want to spend just a minute considering the MOPR in context. MOPR is a troubling development, to say the least, for folks in our industry. But I do want to make sure that we put it in context with regard to the broader set of issues around wholesale energy markets, as well as around the country. So let me talk first about the impact of the broad MOPR. And let me start with, so Romany laid out what resources the MOPR applies to, as well as what resources are exempted. And of course, with the advanced energy technologies that I'll talk about, existing, already operating projects, solar, wind, energy storage, demand response, energy efficiency are exempted from MOPR. So really what I'll be talking about is the application to new resources. And on this slide, I'm showing the amount of advanced energy resources that are already in some stage of development within PJM that are exposed to the broad MOPR ruling. So FERC's order said that to be an existing resource that's exempt from MOPR, you needed to have a generator interconnection agreement on file with the Commission or already signed with PJM. But the reality is that that's pretty much the last step in the development of a solar or wind project in particular. Those projects go through many stages of development, and by the time we've reached that late stage, they are well past the point at which they've committed significant capital into development and an expectation that they will participate in the market. So our member company, Apex Clean Energy, took a look at the queue in February and found that over 89 gigawatts of solar and wind generation alone that's under active development in PJM is potentially exposed to the ruling. And you can see they've broken it down by state here and also between solar and wind. That 89 gigawatt number doesn't include new demand response resources, energy efficiency, or energy storage that may also be impacted by this ruling. And as you can see, no state in PJM is left untouched. Every state has some measure of resources in development. Not all of these resources will necessarily end up being impacted, of course. In particular, at least some of these resources are likely being built to serve a voluntary purchaser. And FERC did clarify that voluntary renewable energy transactions should not be subject to MOPR, should not be defined as state subsidies. Romany mentioned this too. This is kind of another way to look at it. So when you apply a MOPR, a minimum offer price rule or a price floor, how does that impact a resource and its ability to quote unquote clear or participate in the capacity market? So what this slide's showing you is that everything in kind of the gold shaded area to the left are resources that have offered in a price that was under the ultimate clearing price in the market. In other words, that point where the offered supply met demand, the auction was stopped, and a clearing price was set. So historically, we've seen clearing prices roughly in the range of $80 to $140 a megawatt day. In some zones within PJM, locational prices have been closer to $200 per megawatt day, but that's generally been the historic clearing price. So anything that offered above that level would, of course, not clear the market. It would not receive a capacity supply obligation, would not be paid for its capacity, and importantly, as I'll talk about later, won't be counted toward the overall capacity requirements of the region. In other words, the overall amount of capacity that PJM needs to have under contract or committed to meet the region's reliability needs and to meet reliability standards. So anything above that does not clear. And so what I'm showing you there as well is just a hypothetical floor price. Let's suppose a resource is forced to bid $400 per megawatt day by a preset floor price. Well, that resource that might have otherwise bid at a much lower price is now locked out of the market. So I also want to emphasize that advanced energy resources provide a lot of valuable capacity to the power system. You may have heard, if you listen to kind of the debate around this, some saying, well, Wind and solar don't really provide that much capacity anyway. Why? They don't rely on capacity revenues that much. Why are they so upset about this order and about the imposition of this minimum MOPR price rule? Well, first of all, it's important to note that wind and solar perform really well in meeting peak load. Solar generates during that peak period in the summer when you need consistent on-demand electricity. Wind is a consistent performer in the evenings and the early mornings in winter. It's also a consistent performer during extreme weather events in the winter. We've seen that quite a bit. Demand response and energy efficiency are also allowed to participate and provide capacity on a level playing field with generating technologies. And they help meet capacity needs very reliably because they provide demand reductions at peak times in all peak times. And capacity revenues, it's important to remember, are an important part of the equation when you are financing a new wind and solar project. They also, the availability of those capacity payments encourages more demand response and energy efficiency to be constructed than otherwise would. And that goes for whether or not these projects are supported by state policies. And without access to capacity revenues, prices ultimately go up to customers. Developers will pass on capacity revenues to their customers. So imagine, if you will, a power purchase agreement signed with a load-serving entity, a utility, to meet that utility's obligations under a renewable portfolio standard, for example. When that project obtains capacity revenue, that capacity revenue offsets the ultimate power purchase agreement price that is charged to the utility and that the utility passes on to its customers. And that's the correct approach, because that those resources are providing capacity value to the entire PJM region, and they should be compensated for it. And the customers who are supporting those projects should receive some of that compensation. Without capacity revenues, our members have told us that power purchase agreement prices can rise anywhere from 9% at the bottom end of the range for wind projects to as much as 25% for some solar projects. And those prices increases are in addition to the cost of other redundant capacity resources that are procured in their place. And I'll talk a little bit more about that in a minute. So in PJM's compliance filing, it was obligated to calculate and file with FERC a set of default or standard floor prices for every individual technology type. These are off-the-shelf prices that a resource subject to the MOPR can grab and apply and go into the market. As I mentioned, these floor prices are for new resources. They are supposed to reflect what FERC says is a competitive offer from a new resource. In other words, they're supposed to reflect the set of costs that you would expect a new resource to incur and to want to recover if it is going to participate in the capacity market. The difficulty for advanced energy technologies is that FERC required PJM to use a methodology that's largely based on the typical economics of natural gas-fired power plants. Those power plants have traditionally been the marginal preferred next increment of capacity that folks might build to meet rising demand. That has been historically the case. It is not the case anymore, as I'll explain later. But FERC has long required PJM to use this particular methodology. And the end result is that you end up with a set of default floor prices that don't necessarily reflect the actual economic circumstances of solar or wind or battery energy storage or demand response or any of these technologies. But as you can see here, with historic capacity market clearing prices of anywhere from $80 to $200 a megawatt day, most advanced energy resources are at risk if they have to use these default or standard floor prices. And you can see those reflected over there at the right. Really only solar PV tracking, these are panels that track with the sun during the day, and natural gas combined cycle power plants are either close to or assured of clearing at historic prices, assuming that the minimum MOPR price rule applies to them. And actually, one thing that I'll note too on this quickly is that the minimum MOPR price rule applies to all wind and solar projects, regardless of the intent in which they're built, because FERC's definition says eligible to receive a state subsidy or receiving a state subsidy. And because every renewable energy project generates a renewable energy credit that could be sold to satisfy compliance with a state mandate, they are considered state subsidies, even if a voluntary purchaser like Google for its data centers contracts to build a wind farm, it would still be subject to MOPR because it would be considered eligible for a state subsidy. PJM has come up with a process whereby those projects can avoid the minimum offer price rule, but it's important to recognize that. So PJM also proposed, and FERC actually required them to propose, that individual resources be allowed to develop these unit-specific floor prices or plant-specific floor prices. So instead of accepting those default prices I just mentioned, they can bring evidence to PJM and to the PJM Independent Market Monitor to validate the calculation of their own specific floor price. Those evidence and inputs are subject to review by PJM and the Independent Market Monitor. But importantly, PJM's compliance filing allows resource owners to use a methodology that's more appropriate to their technology type. So instead of being forced into a methodology that was developed for conventional resources, they can use assumptions that are more appropriate to their technology type and to their project. And some of those assumptions make a big difference in terms of what that end result floor price is. For example, what you believe the life of the asset will be, the useful economic life of the asset will be, makes a huge difference. And PJM's standard methodology uses 20 years, but in financing, solar and wind projects often use up to 35 years. And so that's one change that you can make that can give you a unit-specific floor price that is much lower. And this process will helpfully alleviate some of the near-term impacts of the broad MOPR on state-supported resources. There's a continued concern that this will become administratively burdensome over time as multiple resources are seeking unit-specific review with PJM and the PJM Market Monitor. And I'll also note that these proposals are still pending at FERC. So we believe FERC will approve them. We don't believe FERC has a basis not to, but important to recognize that they are not final yet. So how will MOPR impact the energy mix and consumer costs as well as state policies in the PJM region? So if the broad MOPR is forcing these state-supported resources out of the capacity market by pushing their offer above the clearing price, then the capacity that they provide won't be counted toward the region's needs. So even if that wind or solar plant, for example, is ultimately built, the capacity that it holds is effectively ignored when the region counts up how much capacity it has to meet regional reliability standards. And the capacity market, of course, because it operates to procure enough capacity to meet all of the region's needs, will procure other resources in their place. And most likely that will be natural gas plants or existing coal resources, because they are subject to either very low floor prices if they receive a state subsidy or no floor price at all if they don't. For states that have adopted policies to encourage these kinds of advanced energy resources, broad MOPR is therefore going to add costs and limit effectiveness. As I mentioned earlier, loss of capacity revenues results in higher power purchase agreement prices. Customers are being forced to buy additional duplicative, unneeded capacity through that centralized market, which causes a significant capacity oversupply. PJM already has very significant oversupply of capacity. Their reserve margin, that is the amount of capacity they hold over what's necessary, is to meet peak load is somewhere in the area of 30%. So that could be one reason why we've seen low capacity prices beyond state policies. And of course, finally, higher emitting and uneconomic aging resources that would probably otherwise retire will be able to continue operating because they'll be able to clear the market when they otherwise might not have been able to. That'll increase costs, and it'll work against the energy and environmental objectives that a lot of states have to replace those assets. There have been a number of cost estimates of Broad MOPR. Commissioner Richard Glick, who dissented from FERC's orders, estimated $2.4 billion per year in additional capacity payments. Grid Strategies LLC, a consulting group, has done a number of estimates. The most recent estimate they cited is $1.6 billion per year. They had previously, prior to FERC's December 2019 order, had estimated something on the order of $5.7 billion per year. I should point out that PJM's independent market monitor disagrees and concludes that Broad MOPR will have no impact on capacity market prices in the next capacity auction, considering the exemptions, the use of unit-specific review, and other things. So want to give you all the data points there on that. I won't spend much time on this because I know that Chairman Stanek will talk about this, but there are a number of potential ways that states may or could respond. The one that's gotten the most discussion is this thing called a fixed resource requirement plan, which essentially allows you to take an entire utility load zone within PJM, pull it out of the capacity market, and bring PJM a plan for how you will otherwise meet your capacity obligations. There's a lot of details that go into that in terms of how much capacity each individual region will have to hold, how much of that capacity must be inside the region versus outside the region to account for transmission system constraints. It's also a 5-year commitment. Once you leave the capacity market, you have to agree to stay out for at least 5 years. So it's a big bet for a lot of states. But we do have states that are actively discussing it, including Illinois, New Jersey, and Maryland. Carbon pricing and emissions trading is another potential option. It won't alleviate all of the impacts of MOPR, but it can put more emphasis on the energy market and therefore alleviate some of those impacts. FERC has confirmed that the Regional Greenhouse Gas Initiative does not trigger the minimum offer price rule, has not said whether other carbon pricing regimes might. And I've listed a few other things here that might be options for states, including really working inside the PJM stakeholder process to push broader reforms to the capacity market that would alleviate the need for things like MOPR. Certainly happy to talk more about that as well. I will say, though, from our members consistently tell us and ask us to advocate with the states and PJM that a patchwork of state-by-state constructs to exit the PJM capacity market could make it harder for them to develop projects at low cost to customers. Let me end with that just a little bit, and I'll try to do this just in 2 minutes to leave plenty of time. Putting the broader MOPR in context. The first thing I want to make sure I emphasize is that MOPR isn't a national policy, and it won't apply everywhere. PJM, ISO New England, and New York Independent System Operator are the 3 regional markets that have a centralized capacity market structure and a MOPR. And FERC's broad MOPR in PJM is actually the most stringent. It also recently issued orders in New York that are close to as stringent, but also have some different exemptions and some different scope, and it'll be interesting to see how those play out versus PJM. ISO New England has long had MOPR. It has an accommodation for states that has unfortunately not been effective through 2 auctions, but does look a little bit different than what FERC imposed on PJM. So other RTOs and ISOs use different mechanisms to ensure resource adequacy, and those don't require MOPR rules. They certainly have their own advantages and disadvantages in terms of their ability to attract competitive supplies of advanced energy from our perspective at reasonable cost, but do want to point that out. And also, it's important to point out that FERC has consistently declined to force other regions to have a PJM-like capacity market, including a MOPR. And in fact, in late 2018, it rejected a former complaint that sought to impose a PJM-style capacity market with a broad MOPR on the California ISO. I also want to emphasize that a market design, an ineffective market design in the case of the capacity market, without a good role for state clean energy policy, does not change the fact that advanced energy technologies are now the most cost-effective option for power generation to serve customers. And this slide shows you that. It shows you that solar PV and wind are more than competitive with traditional conventional options. You can take a look at that slide later, but never lose sight of the fact that these are the most effective technologies available today. That's why so many of your states are enacting policies to encourage them. And the PJM markets will have to continue to adjust to this new reality. Finally, I want to emphasize that broad regional wholesale markets still provide a great deal of benefits to consumers, and they are still the preferred option for our members in terms of being able to develop projects to meet customer needs, to meet state clean energy goals. They offer coordinated dispatch of the most economic energy resources. They ensure greater competition and reduce market power of incumbents. They provide independent operation of the transmission system, which is important not only for planning new transmission, but also for ensuring fair access to the transmission system. So just a few, and I've listed a few more of the benefits there. They've also been a platform for innovation. They've allowed new technologies like energy storage to enter the market, for combinations of energy storage and other technologies to provide critical reliability services. So lots of benefits to broad regional wholesale markets, certainly challenges in the capacity market in PJM, New York, and New England, but don't want to lose sight of those broad benefits as well. And with that, I will turn it back so we can hear from Chairman Stanek.
Thank you, Jeff. I think that was a ton of really great information, and we could certainly spend a lot longer, talking through those issues. Hopefully we have a few minutes at least for questions at the end to kind of delve into some of the issues that you raised in more detail. I do want to turn it over to our final speaker today, the Honorable Jason Stanek, who is the Chairman of the Maryland Public Service Commission. Chairman Stanek will share his experience as states navigate and respond to FERC's order and kind of talk about what may lie ahead. So Chairman Stanek, thank you for joining us today, and I turn it over to you.
Thank you, Christy. Good afternoon, everybody. Greetings from College Park, home of the University of Maryland. This is a timely topic, and I think it's a national one, too, and I'm glad to see that we have such a variety of legislators and staff on the call today. So the question, who decides the state energy mix? I would have thought the answer to that would be the states, but if you were up on the wee hours of Friday night after midnight when FERC issued its orders responding to a number of appeals, you may need to rethink the answer to that, and it could be the feds. So I'd like to touch on this order. I won't use the term MOPR. We've heard that a lot today. But I have 3 points I'm going to make. I'll give you a brief profile of Maryland's energy mix. I'll talk briefly about the order, and then what our options are going forward. So Maryland has been a member of this grid, the PJM grid, since the 1950s. And together, like states in Midwest ISO or ISO New England, we have our own consensus-based organization that represents us in various forums, and that's called the Organization of PJM States, or OPSI. States, obviously, as you saw on Romney's slide earlier on, are moving in various directions to decarbonize their energy mix over the near term, and Maryland is like many of our other colleague states in having a very progressive vision for its energy future. We were the first state in the country to launch a tax credit for energy storage. We have a goal of getting 300,000 electric vehicles on the road in the next 5 years. We have an RPS of 50% by 2030, and we hope to have considerable amounts of both solar and offshore wind coming online in the next coming years. We also have been working very hard on time of use pilots and other grid optimization projects, which has ranked us third in the country behind California and Illinois in terms of adopting innovative grid policies. However, we're a relatively small state, 6 million residents, and we don't have a tremendous amount of natural gas, oil, and other baseload resources in our state. So unlike some others, we are a net energy importer. As of last year, we import about 30% of our power from our neighbors. And pursuant to our state law, we could actually import power from about 26 states where we buy renewable energy credits from. So it shows you that we are a little more reliant on our neighbors. We're reliant on the PJM grid and competitive wholesale electricity markets to supply our needs. As you heard earlier from both Jeff and Romney, PJM it's a regulated entity by FERC, whereas we, the PSCs and the PUCs around the country, we are the retail energy regulators. So speaking for myself and Maryland and many of the PJM states, we received the final rehearing orders from FERC, like I said, on midnight of last Friday. And for some reason yet to be explained, at least to myself, FERC has dug in its heels on the position that the actions by its states to decide its own energy mix result in impermissible interference in FERC's wholesale electricity markets. FERC has gone great lengths in this decision, and if you haven't read it, it might put you to sleep, but it's several hundred pages long. It has nearly 1,000 footnotes, but they do explain that it is within their authority to nullify the effects of state policies that have the potential to affect and impact wholesale rates. I would say that the states, without exception, vehemently disagree with that position and found that FERC's initial decision 2 years ago, finding that the current regime was unjust and unreasonable, is unfounded. You may have heard one of the FERC commissioners describe the order as stunningly awful and plain garbage, and that was Commissioner Glick, as Jeff Dennis mentioned a few minutes ago. So in the state of Maryland, we had 4 separate units of the state file rehearing an appeal of the decision that included the PSC, the ratepayer advocate, the state energy office, as well as the state's attorney general. And we argued that it was within FERC's burden to demonstrate that the former rules were not just and reasonable. FERC, in my opinion, danced around or did not address a number of our arguments on rehearing. It's interesting when you take a look at the fact that PJM is actually regulated by FERC to see PJM actually make the argument that there needs to be a balancing of state policy objectives as well as federal interests. And we've seen that a lot recently because we've had a number of cases go to the Supreme Court where the court made quite clear that there is this delicate balance between federal wholesale regulated markets and the state regulated retail markets. So PJM went so far as to talk back to FERC and stated that FERC was needlessly interfering with state resource policies well beyond that what is needed to protect the market against any inefficient price formation. You heard from the previous speakers, there's lots of exceptions, competitive exceptions, unit-specific exemptions, existing resource exemptions. FERC has also gone ahead and exempted all resources that receive some type of federal subsidy. So it's, on one hand, very laughable to say that we're going to be trying to get to a competitive level playing field when you have so many exceptions on the ground. But on the other hand, you have the impacts, and I think both Jeff and Romney adequately explained how the resource mix will change depending on the rules for the market, what resources clear and what resources may not. And in the case of this expanded rule, the MOPR rule, you'll see a lot of the newer, cleaner energy resources move to the back of the line and to a place where they would not clear the market, they would not be called, they would not receive any of these capacity payments. So that was a disappointing read for us. My last point is, where are we now and where are we going? So 3 points on that. We're evaluating our legal options to go to court. Since last Friday, at least 4 parties have already filed lawsuits around the country, both in the 7th Circuit and in the DC Circuit. So those appellate briefs and requests for appeal are due on June 15th. The second item that we're actively working on as a state is responding to PJM's compliance filing that was made last month. Again, a very voluminous document, somewhere in the neighborhood of 500 to 600 pages, implementing what the new rules are. And I have to say that PJM, as a grid operator, has been very constructive as a partner with the states because they understand what's going on. They do see this as needless interference by the federal regulator. So we're working on that, hoping to make sure that we get the PJM compliance filing in as best shape as we can to protect the resources that our state and other states in PJM would like to prefer and add their public policies to. Third and the last point is we are, as Jeff Dennis mentioned a minute ago, evaluating whether or not it's in the best interest of the state of Maryland to exit the market. And he mentioned the fixed resource requirement, the FRR. Basically, that is just an exit ramp that allows states to say, you know what, we don't want to participate in the PJM capacity market anymore, and we'll enter into bilateral contracts instead of bidding in resources. Hard to say whether or not that is a net benefit or a possible complexity to our ratepayers. There are costs associated with that. There is also some potential benefits, but it is not an easy calculus to make, and we're in the midst of that right now, trying to figure out, do we take aggressive steps such as Illinois, such as New Jersey, who are actively investigating whether or not to pull the emergency brake and exit the PJM capacity market. Maryland isn't there yet, but we're looking at that. We're lucky to have some very well-attuned legislators in our State House in Annapolis that formed a work group to look at that, along with PSC staff and other interested stakeholders. So the last chapter of this soap opera hasn't written itself just yet. It's going to take a little while longer. But my hope is that instead of discussing everything that we've just seen on the very well-done slides of Romney and Jeff, that we begin to figure out what comes next, because the construct that we're dealing with right now is not durable. It doesn't have a very long life expectancy, in my opinion, and it would be a better time of our resources to figure out what is going to replace the existing PJM capacity market. And with that, Christy, I will yield back.
Thank you, Chairman Stanek. I think those remarks were great and gives us sort of a little bit more insight into specifically, you know, how Maryland and the Commission is sort of handling this current situation. I do want to turn it over to the audience and remind everyone, if you do have questions, feel free to type them into the chat box, and I will try to get to them in the final few minutes of the webinar. While we're waiting to see if anyone has any specific questions, you know, maybe something just that's kind of building off of what Chairman Stanek has been discussing. You know, we've obviously, this conflict between state initiatives and competitive markets has been building over the last several years, and we're really kind of seeing it come to a head now. You know, what are your thoughts, or sort of what is the best way that each of you as the speakers on this webinar see for, you know, one, maybe preserving the competitive markets while also incorporating the various state goals? And obviously those are all unique around the country. And so I open that up to anybody kind of willing to answer or talk about it.
Perhaps I'll just jump in first. This is Jason Stanek. We did initially consider something that would allow the competitive markets to remain, and that's obviously very, very important. So the state of Maryland came up with a proposal to allow a side-by-side auction where states that have particularly policy resources would have those resources bid into a competitive auction that is not the same and commingled with traditional resources. We believe that would have preserved the capacity markets and allowed for competitive outcomes all the way around by accommodating the state's interests pursuant to both the Federal Power Act and the Constitution. But FERC did not see in its judgment that was a reasonable path forward.
You know, and I'll just say at a high level, this is Jeff Dennis, I'll just say at a high level, because, you know, there's a lot of details we can get into, but I think that a lot of this starts with really a pretty strong and concerted pushback with FERC and with the federal government on not so much the details of MOPR, although, you know, obviously as Chairman Stanek mentioned, there'll be legal challenges and we'll all do that. but on the idea that the markets are, that state policies are something to be mitigated rather than something to be accommodated inside the wholesale markets. That is an entirely new policy position, not one that as you heard, I have many years of experience in and around FERC, and not one that we've ever heard before. And so we are encouraging everyone we can to say to FERC, you need to rethink what the goals are of these markets, because they really won't be markets anymore if you don't. In terms of working inside the PJM stakeholder process, I think that there is a lot of work that can and should be done with like-minded interests who do have votes inside that stakeholder process, do have a voice inside that stakeholder process, to start advancing reforms to the capacity market that would better incorporate state policies. You know, there was in the chat box, there was a mention of the fact that, you know, states and consumers don't have as much of a voice as they should inside that process. That's absolutely right, and more needs to be done to make sure that states have a voice there. But PJM itself has said publicly that they don't believe this result is sustainable, which Chairman Stanek mentioned as well. So PJM, I think, at a staff and a management level, has an interest in continuing to explore alternatives. And so states actively engaging in that, actively finding partners like our members, members of other trade associations, other groups, can start us down that path. It will be labor intensive, it won't be easy, but there is a path there.
Yeah, this is Romney. I very much agree with Jeff's comment at the outset that, you know, we are seeing this shift towards away from trying to accommodate state policies in the market towards trying to them. I think that's really an important thing to understand and something that does need to be addressed going forward. As a general matter, I think there are really interesting ways to better, I guess, if you like, align the markets with these overarching state policy goals, for example, through carbon pricing or other mechanisms. But also, I would just like to reiterate the chairman's point that, you know, this is a very partial solution to what FERC's claiming as a problem. It is not addressing federal subsidies, as I said. It's also not addressing certain state subsidies for existing resources and others. So the construct is partial in itself.
Well, thank you all for that. And I know we're just about out of time. So if there are questions in the chat box that we haven't got to, I think, you know, we could follow up over email separately. I guess, you know, kind of one just quick question to round us off is, you know, Jeff, you mentioned that obviously the MOPR isn't a national policy, but, you know, are there potential implications for the ruling sort of on other regional markets? And can you talk a little bit about maybe, you know, what that can mean for state mandates and other markets across the country, if any? And I know you kind of touched on that a little bit in your slides.
Yeah, I mean, the most direct impact is obviously any other market that has a centrally cleared capacity market. So that's ISO New England and New York ISO. The other regions, of course, do this differently. So I don't believe that it will have a long-term impact on those other regions. Now, to the extent that this is an indication that this particular composition of FERC is looking to take steps to exert more authority over state policies beyond simply, you know, the specific facts here, which are the impact that so-called state subsidies have on the capacity market in particular, then maybe there could be spillover effect. But putting my lawyer hat on, putting on kind of just my reading of the precise facts that led to this conclusion, I don't believe, and I wouldn't expect that it will have a lot of spillover effect in other regions. Now, it is an important lesson for places that are considering broader wholesale markets, like in the West, like in the Southeast, about not only how to construct market designs that don't lead you into these kinds of problems, but also how to ensure that states have an active and central role in the governance of the RTO, because that is something that's missing in PJM for sure.
Well, thank you. And I know we're running out of time, so I will go ahead and close this off here and just say thank you to our speakers. We greatly appreciate the expertise each of you were able to provide. And of course, thank you to all of our attendees for participating in today's webinar. As a reminder, we will have a recording of today's webinar and the presentation slides made available very shortly. So if you had any problems downloading the slides today, we will get them up on the NCSL website. Our next webinar will be in 2 weeks on Thursday, May 7th, and we'll examine the waters of the U.S. rule. To register or find out more, you can log on to ncsl.org, or you can send my colleague, Kristen Hildreth, an email. And with that, I will close this out and just say thank you for your continued interest and support of NCSL, and everyone stay well. Thank you.
Thank you.